Hi, one second. Yes, hi, good afternoon. Today is May 4th, 2026, and it's 3:40 p.m. US Central Time. Excuse me. And my name is Rinaldo J. Aguiar Marcano, and I'm recording this from my office located at the 2302 Britton Ridge Drive, Katy, Texas, 77494, 300 feet away from the house of Robert Mueller, former director of the FBI. This is the second segment of um, the declaration D134. And so in the first segment, I described the situation that why the network was panicking, right? And is panicking. And well, to be honest, now that I went out, it feels like the panic is passing, and now they are on the second stage of grief, which I think is acceptance, right? So the first one, denial, right? They couldn't accept the situation they're in, but now they're accepting it a little bit. I mean, I guess they're, yeah, acceptance. I think it is, right? The stages of grief is what I'm talking about. But anyhow, so I described that, and I explained how we had this pre-trial hearing scheduled for today at 1 p.m. and I had to go there. That's why I cut it short. I mean, the previous segment. So I went there and saw what unfolded, and I just came back and I'm recording this to report to you watching this what happened, right? But what is the best way to do this? Before I go into the details of give me just a second, okay, one second. Before I go into the details of what happened, let me tell you what I did before going there, because I did a couple of things that I didn't tell you about. So one thing that I did is, and I have done this. I mean, I had this prepared days ago, right? But I didn't deploy it on purpose, and I waited until the last possible moment. I made some changes to it today because of certain things that I thought of, but the core document was already prepared. Okay, so this document it wasn't a core document. It was a document, and I'll show you the document in a second. But it was another of those scholarly articles that I produce um, to be submitted to law journals in the U.S. Mostly, but also in other countries. But this is a special. It wasn't a special article, right? It was different because I mean the previous articles went into a lot of details of a specific case or a specific allegation, right? And touch on the surveillance and the theft of intellectual property, like accusations, right? Like they went into criminal activities. Um, but for this one, I did something different. So what I did is that I found the commonalities across all these cases that they have been using to harass me for the last year. They have a couple of things in common. Yeah. I started thinking about what are the things that are common. I mean, what are the weapons really? Right? Because they may seem like different cases. One is a family case, the other one is a traffic citation, the other one is an HOA dispute. They may look disparate, but in reality, fundamentally, they're the same thing. They have fundamental things in common. So once I saw that, I thought, I should write an article about what's common, right? Instead of writing different articles and targeting them separately. Find the commonalities, analyze them deeply, and write about that. Because in the commonalities lies also the proof of the concept of the mind of the people in this RICO enterprise, which is a predicate that the authorities will need to convict them, right? So by tying them together with the same techniques and the same modes of operation, I guess, in the different courts that are radically different in jurisdiction, I mean, on the substantive issues of what they have jurisdiction on, it shows, right, that they are RICO enterprise. So, if you think about it, right, the common thread about these three cases, and all the other cases, well, like The cases in the Southern District of Texas and on the Fifth Court of Appeals and the Court of Appeals of the Fifth Circuit, like all of those, it's the same thing. It's a combination of two things. Okay, one is it all starts really with either a defective service or an unexistent service. For example, when they created in the family court, right, when they kidnapped my son, they created an order, right, to justify the removal of the child without them going to jail, right? That's what they thought. Um, so they created an order, but they didn't serve me that order. They served me another version of that order that wasn't the real order. Because if I had the real order, I would appeal it. You see? So it all starts with non-service or a defective service. Another example is the case in the 268 court, where they were going to sue the company that owns this property because they have, I mean, it's not, Rinaldo doesn't own the property, it's the company, right? So they have to sue the company. So Phil Denning wanted to sue the company, right? But instead of serving the company in Delaware, which by law is what he needs to do, he served me, right? And named me registered agent of the company, which is not true. I cannot be the registered agent because it's a company in Delaware. The registered agent has to be in Delaware by law. So see, in this case, they did a defective service, and because they served me and not the company, I'm not going. I cannot. Even if I wanted to, I can't respond to that because I'm not the company. You know, the thing is you know, it's absurd. And even if I respond, they will invalidate my response saying that I'm not the company. You see? So in that case, it was a defective service. But without the defective service, they sue the company, and because the company cannot possibly respond because the service is defective, I mean, they are creating the condition that makes it impossible for the company to respond. That's what I'm getting at. And then when the company doesn't respond, because even if it does, they will invalidate that. Then they proceed to have a trial without any representation for the company, and they enter orders against the company without the company even hearing the allegations. And then when the company doesn't complain, not complain, doesn't comply with those orders because they're void and you know it wasn't never even notified, then they move to find the company in contempt and for sanctions, right? And when the company doesn't pay the sanctions, then they move to find the person, the supposed registered agent, which they put me as registered agent, liable, right, and personally responsible for all the you know contempt of the courts and all that. And then eventually they can put the person in jail. But you see, it all starts with a defective or an improper service. Or even non-service. Like in the case of the family court, they didn't even serve me with the order. They gave me something else. And in the case of Justice Place 1.1, Judge Kelly N. Crow, which is the instance of today, is the same because I filed 2 motions for discovery. Their obligation was to serve me with those documents, especially because I'm acting pro se. You know, like the state has all the advantages. They have to serve me with a lot of time, so I can't respond to that. They have to send a process server, I don't know, register mail or something, and send me the evidence in a way that they have a proof that they served me, right? They never serve me any documents. I file a motion to recuse. Their duty is to rule on that, produce an order, and serve me with that order. So I can, if I don't agree, I can appeal it. They didn't serve me with the order, right? Until today, I didn't know what happened to that. I just found out what happened. I'll tell you in a second. But for months, I haven't even known what happened to that order, right? To that motion to recuse. So, but you see, it's the same. Is in that case is on existence of the service. So the service didn't even exist. They didn't serve me with the discovery documents. They didn't serve me with the response for discovery, and they didn't serve me with the response or the order resulting from my motion to recuse. So you see, all these cases, what they have in common is that the violations of the process start really with the violation of the requirements on serving, on legal serving the other party. That's how everything starts. Um, And the second component that enables these crimes, these judiciary frauds, is Tyler Technologies or similar companies. Maybe in other states it's a different company, right? But because they need to hide that the order, right? When they create an order to harm a person or an entity, like for example, when they kidnap the child with index number 7 in the in the in the 387th court, that order has index number 7, but it's hidden. If you go to the case summary, that number is missing. You cannot click on it. You cannot download it. I went 3 times, 3 different occasions over in different months of the year, 2026, to the court physically and asked for a copy of index number 7. At the clerk, the 3 times told me, we cannot find this document. It's not in the system. Right? So this is what they do. They hide the real order so the target doesn't even know that it exists, and give the target or the entity they want to harm a different order that has the same title, but it's a different document. So if the target gets upset and appeals it, when the target appeals it, they go to that court where the target filed the appeal, and they show them the real order that doesn't match the allegations that the target is making. So they go and say, this person is crazy, and look at the document in number 7. This person is being, their mental capacity is being challenged by his wife or her husband. Right? The wife is saying that he is psychotic, that he's paranoid, that he's whatever. Right? And you can see that here. He's filing this appeal that doesn't have anything to do with the actual order. Right? That's what they say to the judge on the higher court. I imagine, right? I wasn't there, but it's logical that that's what they do. And that plays on the narrative that the target is crazy. And the judge is seeing this index number 7 they're showing, this appeal from this person that is allegedly crazy, that has nothing to do with what the document says. They deny the appeal. Right? And this has happened in all these cases. Like for example, in the 268 as well, there's document indices in the docket that are missing when they issue these orders, because they need to be able. And I explained this in other demos before, or the declarations. They need to be able to switch them if the DOJ opens an investigation. Right? If there's an investigation, they're going to switch the orders, and they're going to give to the DOJ the index number 7. But if I go and ask for the index for the order, they will give me index number 8, which is visible. That one is visible in the docket. But if they see that the DOJ is investigating, they will make index number 7 be number 8. Okay? And to the DOJ, it would look all legit. But as long as the DOJ is not investigating, index number 8 is, for me, one version. And for appellate courts, it's really index number 7. That's basically the TTP. It's deception. It's I don't know. It's a scam. I don't know what is the best word for this in English, right? It's a confidence scheme, I would call it, right? Because they're confident that they can trick different people that are not connected to each other by switching things in the docket, because they have the support of Tyler Technologies or similar companies to do this, right? Because if Tyler Technology wasn't enabling them, they wouldn't be able to do this switcheroo. Right? The documents would be unmutable. The docket itself would be unmutable. The dates in the documents would be unmutable. The documents would be clearly labeled as in Pacer. So obviously, right, there's design, there's engineering on the design of Tyler Technologies to make this possible. This is not that they found a loophole. The loophole was built in for them. And that's important, right? It's important to understand, if it was the chicken or the egg that came first, right? So those are the 3 things that are in common, right? Those things are in common in all these cases, that they have been targeting me for over a year. So what I did was that I created a commentary article for law journals, basically as a case study of 3 different cases. So 3 different cases study. In the case studies, I am not saying that they are of the same person, right? So if you read this as a reader or as an editor of a journal, you are thinking that these are 3 separate cases, unless you go and look in the cases, right? If you look in the cases, you will find the names and you will say, oh, it's the same person. But as long as you don't do that, it's not explicit in the document that is the same person, right? So you might be reading this as a clinical analysis. It really looks like a clinical analysis, right? And it is. It is a clinical analysis. So from the perspective of a reader, all you're reading is that there's all these series of irregularities on at least 8 or 9 different cases in Texas courts in which the common thread is that there is always either non-service or defective service on purpose, right? Defective on purpose, followed by uh, record manipulation using the platform that keeps the records for the courts. And that enables judiciary fraud to harm a person, specifically their constitutional and civil rights. So this is the framing of the article, right? And then after I do this clinical analysis, at the end I include a notice of actual knowledge. It's a notice directed to the editors of these journals, the academic deans of these universities, and the readers if it gets published somewhere, telling them that Tyler Technologies is an active provider of the courts on a list of states in the United States, and it lists the states. And this notice tells them that because they could be, if in the event that they're officers of a court, or that they're a student aspiring for registration with the bar, they have a duty to report these because they're seeing these. They have actual knowledge that these crimes are being committed against the courts, and that they could have been committed against the courts of their own state. So they gain immediately a duty to report Tyler Technologies to the authorities in that state. It's ministerial. They can't elude that responsibility. Um, or they would risk disbarment or denial of registration if they're students. So I give them the notice, right, in the same document. And I send this to something, I started with like 150, right? But I can go all the way to 1,000, right? If they don't stop the harassment, I will go up. So I sent this to like 150 law journals, but not any, right? So like very specific and strategic ones, like the ones that talk about or that publish articles on constitutional rights, civil rights, family law, criminal law. Um, and in this document, they're also attached all the dockets of these courts showing how they're hiding the indices, right, with Tyler Technologies. I mean, the actual dockets are attached, and I had to attach them because, well, the article talks about manipulation of records. If I don't attach the documents, what they will do, they will manipulate the records to make them look okay. And then a reader will read this, will go to check the cases, and will think this person is crazy, which is exactly what they've been doing for a year. So to prevent that from happening, I attached the docket summaries to this article, and I sent it to like 150 specialized law journals in the US. So now, and I did this 45 minutes, an hour before the pre-trial started, on purpose. I could have done this on Friday, but I did it an hour before. Why? Well, because I know that everybody is at work. They cannot coordinate. They cannot, I mean, they could, they probably, because they have the secret app and all that, but it's way more risky than if they are in their $3 million home, surrounded by 2 acres of terrain, right, of land that nobody can intercept them. If they're stuck in the court, in this, the court is also surrounded by a buffer, right? But still, there could be an FBI agent in there, right? That they don't know. So it's riskier. So my play here was, well, I'm going to put them in a situation where, yes, they're going to coordinate, but they're going to incur into more risk in doing that, and they probably are going to limit what they talk, right? It's going to limit their capabilities of coordination, and also because they only have 1 hour. The pretrial was at 1 p.m. and I sent this thing at I think it was 11:48 or 11:50, 70 minutes, right? In fact, let's check. The Maybe this is a good time for me to share my screen with you. 1 second. Mhm. Sorry. Yes. So I sent this. Here's a receipt. I sent this exactly at, or the time is on, the time zone is not correct, but I can tell you it was 11 because I can see the 52 minutes here, right? It was at 11:52 a.m. Central Time, and the hearing was at 1. The pretrial was at 1 p.m. So that gave them less than 70 minutes to do whatever they wanted to do. Right? And this is important because this article, in fact, let me see if I can show you the article now. Yes, so this is the actual article, and you know, yeah. So you see, it has the first case study is the 387 court, right, where they issued all these orders to kidnap the child. Um, then there's a second case study, which I think is this one that I went today, right, to the Justice Place 1.1, and then the third one is the one on the 268 court. Um, And then here's the notice of actual knowledge to editors, academic deans, and readers. And I'm basically telling them, listen, if you live in a state where Tyler Technologies have operations and is running the courts, and I give them the list of states in the next page, which is here, right? So it's 4, 8, 12, 16, 20, 24, 28 states. I'm giving them basically instructions on what they should probably do, right? I mean, it's not legal advice, but it's a strong recommendation based on the law. One, they have to report these allegations, right? And so the authorities can conduct an investigation independent from Target Technologies and assess whether this is the case or not. Secondly, they have to conduct audits in the case they have clients, or if they, even if they're a student. So sometimes law students, they advise people, like in the law, I don't know what it's called. The law libraries, and like they give this community service of providing free advice to people that cannot afford it, right? So if they have advised people, they should check the dockets of the people that they have advised to see if they have these docket index numbers missing, right? um, and also if they read this document, this article, right, and they go and check one of these cases that are detailed here, which the evidence of the manipulation is attached to this, and if they go and check in the live version of the dockets and they see further discrepancies, they are obligated to report those new discrepancies. Like, for example, if the 387 court and the clerk of the district courts in Fort Bend now goes and tries to fix the thing by showing the index number 7, that would be a new discrepancy, because in the snapshot that is here, it's clearly hidden. So if now it shows up, the person that notices that has the obligation to report that to the authorities, right? I mean, if they are an attorney, or if they are registered with the bar association, or if they are aspiring for registration on the bar. So it's a ministerial duty. So it's not something that they can elude without risking personal consequences on their careers. Um, so that's what I did, right? And then here are the attachments, right? Here you can see, for example, I'm not gonna show you all of them because it's a lot of documents, but if you see this, right, you can see here what I'm telling you, right? So you can see the index number 5, you can see the index number 6, and it jumps to index number 8. The index number 7, which is the real order that they have hidden, that they never showed it to me, that one is missing, right? And in this docket, in this same case, there's like at least 6 or 7 instances of missing indices like that, and they're all orders. And there are other irregularities, right? Like after an order, because I'm a pro se litigant, according to the Texas rules of procedure, they should serve me with the order. You can see here that they did not serve me. Like after that supposed restraining order, index number 8, which is not the real one, but you know, it says here clearly unserved, right? So I mean, not even right, not even the wrong order they serve to me. But anyhow, so that's basically what this article was, right? So I sent this to all those journals, law journals, and then I went to the court. When I go to the court, I'm going to describe. I'm not going to litigate the issue here because it's obviously a series of more violations of the process, right? But I think they made a terrible mistake. So I'm going to focus more on that than on the other violations, right? But the main things are that, well, first of all, when I get there, the prosecutor starts talking to me. It wasn't the judge. I haven't met the judge the first time. Right? She's shielded by the prosecutors and the clerks. And I'm guessing I will never get to talk to her until this goes um, to a different forum, I guess, right? Where the roles are reversed. Um, so when that happens, I probably will get that chance, right? But until that happens, I know that I won't be able to see her. So anyhow, um, the situation is, right, I get there and the prosecutor starts telling me that they cannot give me the video recordings. Right, she gets right into it. I say, well, but wait a second. Before we get into that, there is a pending motion to recuse. I can't even talk to you if there is not an order for the motion to recuse. If it does not resolve, I cannot engage, right? Because I would be waiving my right to an automatic stay. She says, no, there is an order to the motion to recuse. It was denied. And she tells me, look, and she shows me a paper that has a handwritten note. And that paper, I recognize it, is the actual motion that I filed. So she is showing me my own motion that I filed on March 23rd, I think, or March 20. She's showing me that paper, and it has a handwritten note on top. And it's hard to read, right? And she's telling me that it was denied. And I tell her, listen, but I need to see the order. I want a copy of the order because I'm going to appeal it right now, right? When I say that, her demeanor changed. She was like, "Oh well, I have to look. I have to see, where's the order, and then I don't know what it is. I can't find it." And she went. She left the room. Right. She came back like in 10 minutes, and then she told me, "Listen, here's the order." And then she shows me again the same document with the handwritten note, and it says denied. And it had a note saying that the judge KP George is not the administrative authority of that court, and on top of that, that he was already removed from his post. This is because in my motion to recuse, I made several arguments, right? I said, and don't quote me on the order, right? Because I might be getting it wrong. I will have to read it. But more or less, I said, I'm suing the governor of Texas in federal court. I'm suing on a Monell claim Fort Bend County as a whole. I'm suing the sheriff office, the Fort Bend sheriff office. How can I get? And then my fourth comment, the last thing I said was, and on top of that, I published a book about KP George, who is the county judge and is indicted on 2 counts of money laundering. So of all the things that I said, the only thing that she read was KP George, and she denied the motion based on that. I mean, all the other things still apply. I mean, Greg Abbott is still the governor of Texas. I'm still, pursuing, and I will keep pursuing for as long as it takes, all the civil recourses I can against all of them. I mean, that is still a fact. The book is still published. She is mentioned in the book. I mean, all of those things still apply, but she only focused on the one factual thing that she could refute to deny, supposedly, the order, right? But okay, I'm not going to litigate that because I would appeal it, right? But I can't appeal it. Why I can't appeal it? Because it's not an actual order. What she did was to write a handwritten note on a motion that I filed. That is not a legal order. I mean, what is this? I mean, forgive me for saying this, but I think I can say this because I live the first part of my life in a country that is a third world country, right? This is the kind of thing that happens in a third world country, right? Where somebody with authority writes something by hand in a piece of paper, and that has the power of law. Like, they can put somebody in jail with a handwritten note. That happens in Venezuela. Or you can go to a doctor, and the doctor can order a life-altering operation using a piece of paper and writing it like in something that is even hard to read. But they cannot be doing that in this court. This is a criminal court. They have to issue a document, a formal order saying, this court, and it has a format. There is a format for these things. Like you have to say the date, what was the issue, what is the case number, who is the clerk, what were the arguments considered, and then there is the decision, right? But all these things need to be explicitly spelled out in that order. It has to be a standalone document. It cannot be a sticky note, a staple on top of my motion, right? So I can these things that she gave me, that she's saying that it's an order, it's not really an order, because I cannot take that to a court of appeals. Obviously, they're gonna laugh, right? They're gonna dismiss it, saying this person is crazy, right? Um, but then I go to the teller, right, to the clerk's window, and I did what I do, right? I asked for a copy of the docket, right, because I want to see the entry in the docket produced by Tyler Technologies of this supposed order denying my motion to recuse. When I do that, surprise. Let me show you what. Let me show you what they have in there, right? So this is what they did this time. I mean, I understand, right? They don't have much room to do anything at this point with that. So they did what they could. Let me see if I can find it. Yes. So this is the docket, right? So this is the printout of the docket. And if you scroll down, you will see that my motion to recuse was filed on March 20, right? And it says motion to recuse, denied, right? But the date, I mean, this is not an entry for the order denying the motion. This is an entry for the motion on itself. So basically, there is no entry for the order. What is the order, right? Like, this is not the order. This is the motion, right? And then I also scanned the document that she gave me that she is portraying that is an order, but it's not really an order. So see, this is my document. You can see that it says that the defendant, Rinaldo J. Aguiar-Marcano, appearing pro se, files this motion. So this document is my motion, right? And then what she did on the second page, she put that handwritten note. Then you can see that, right? So it says denied. This court is not under administrative control of KP George. Additionally, KP George has been removed from office. But like the most concerning things, which is the governor of Texas and the police, the sheriff, the Fort Bend County Sheriff's Office, which are the first, and also the denial. Like in this motion to recuse, I make the point that when I went to the court on February 4th, to this very same court, the bailiff didn't let me enter the courtroom. And the clerk refused to file documents. I mean, they already violated due process to me directly on this very same court. How can this court be partial, right? So she did not address that, which is the most serious thing. And also, on top of everything else, I mean, by signing this, she's acknowledging that she read this document, right? And if she read these serious allegations, some of them committed on her own court by her own clerk, and she's not going to take action against the clerk. She's not going to report the clerk to the, I don't know, to the clerk's school, to the clerks, to the bar of clerks. Like, I don't know what would be, right? I imagine there must be some regulatory organism that manages, that controls that the clerks don't go wrong, right? She has a duty to report that clerk, because it's obvious that the clerk is committing criminal obstruction of justice, right? I mean, there's at least the allegation. She has to investigate this, right? But instead of investigating it, she just denies with this. Doesn't really. She writes me like a sticky note, basically, telling me, no, I'm not going to recuse myself, right? But this is not really a legal order. I cannot appeal. How can I appeal this, right? So this is another violation of the process. But the most important thing is that in the docket that I just showed you, like if you scroll up, you will see that there is no entry for the actual denial of the order. So there is a motion, but there's no corresponding order. And because of that, there is also no service. They didn't serve me with that order. Like if I don't go today to that court, I never learned that she supposedly denied this on April 14th, right? So what I'm telling you is that there is a missing entry here for, according to her own signature, April 15th, with a denial, an order denying that motion. It's not in there. And this docket summary is printed by Tyler Technologies. So basically, she is confirming with that signature everything that I wrote in that article an hour before I went to the court. I mean, I cannot have preemptive knowledge of what's going to happen in the future, right? So if I wrote that article, and the article describes exactly what happened 1 hour after what this the only logical conclusion you can draw from this is that this is a TTP. This is something that is heavily standardized and that they do to everybody. So, I think but I think this was possible because I sent, I mean, to show you this, right? It was possible because I sent that article 70 minutes before going to the court. If I had done this on Friday, they would have designed and coordinated among all of them, because I mean they're pretty high level, right? They're judges, right? They would have found a way to create a situation that explains the thing, right? Like, it could be an administrative mistake, it could be whatever, right? The judge got sick, like whatever. But they would have created something over the weekend, right? But because I gave them only 70 minutes, and during a time window in which all of them are at work, then they got handicapped, right? And this was the best they could do, right? But this, to me at least, it shows clearly that it's. So no, I think it was a terrible, terrible mistake. Now. So but to give you the last, so they set a trial date for August, like 6 months in the future. So basically, they're going to keep, which is what I just said before recording this segment, before going to the court, that extending this is a further denial of due process on itself, because they are denying me the right to get rid of this problem quickly. Like it's a to give an idea, if they were to issue a fine for this, it would be something like $100. I don't know the amount. Don't quote me on that. Like, it could be 200, but this is something that is trivial, right? And they're making it so difficult because and so long in time, because this gives them an opening to keep dragging me to court every time they need, to harass me, to find me in contempt, whatever. Right? And more importantly, to justify the false police report that Phil Denning filed on behalf, probably, of Robert Mueller. Right? So that's why this citation is so important, right, to them. Yes. Yeah. So I think I'm gonna close this segment here. To not mix technical topics with legal topics, and I will just append it to the previous segment. And then I have a few technical things that I want to tell you about that I think are interesting. Um, but I'll save that for the next segment. Okay. So I thank you again for your time, and I'll see you on the next one. Bye. Hmm. Un segundo.